You're listening to Broadcast Blue, brought to you by Leo Law. Now, here's your host, retired FLETC senior legal instructor, Bruce Allen Barnard.
Hello and welcome to Broadcast Blue. If you were a previous listener, we had the episodes running a couple years ago. It's been a minute. We took a couple years off and we've been doing a few projects, but we're back with Broadcast Blue. So welcome back for those of you who were here before. My name is Bruce Allen Barnard. I'm a former federal prosecutor, a retired military officer, a retired senior legal instructor from the Federal Law Enforcement Training Center. And I'm basically here just to provide you with the legal updates, the latest on the legal aspects of law enforcement. That's what we do every week here at Broadcast Blue. We go through the appellate decisions that are decided at both a state and federal level, and we look through these cases. We pick out the ones that seem to be the most relevant, and then we provide you with a very timely update. Nobody does it quicker. You can see legal updates that are 6, 7, 8 months old, but we provide updates on the cases as soon as they come out. So again, welcome. This is episode 2024-24. That's the week that we are in of the year. So we're in week 24 for the cases ending the week June 14th, 2024. Let's take a quick look at the cases that we're going to be talking about in this episode. This week on Broadcast Blue, we have a number of search and seizure cases. Some weeks we have more cases than others, but we had a number of cases this week. We are going to take a look at United States versus McMullen from the 6th Circuit, United States versus Mendez from the 7th Circuit, United States versus Hoft from the 8th Circuit, Johnson versus Smith from the 10th Circuit, and our state cases from Delaware, Kentucky, and Georgia. We have Matthews versus State from Delaware, Ellis versus Commonwealth from Kentucky, and Tatum versus State from Georgia. And even though the use of force is a Fourth Amendment issue with respect to the civil lawsuits of Title 42 of the United States Code, Section 1983 cases with federal officers, Bivens cases, but we separate the use of force cases out from the search and seizure cases, even though they're both Fourth Amendment. And this week we have Colon versus the City of San Jose, which comes to us from the 9th Circuit. So let's start with a look at the search and seizure cases. The first case that we have in this week's podcast is United States versus McMullen. This case comes to us from the Court of Appeals for the 6th Circuit, dated June 7th, 2024. Shortly after midnight on September 16th of 2021, Cleveland police detectives were surveilling a neighborhood that was known for gang activity and violent crime when they saw Dorian McMullen sitting in his car with his leg sticking out of an open door. As they approached in an unmarked vehicle, they observed McMullen reaching for something on the car's floorboard, and they suspected that it was a firearm. McMullen exited his vehicle, engaged in a brief conversation with the detectives, and they frisked him. And they asked him about what was in the car. He admitted to having a firearm and crack cocaine in his car. One detective shined a flashlight into the vehicle and saw a gun, and the detectives then did a protective sweep, basically a Terry frisk under Michigan versus Long, of the passenger compartment of the car, finding a loaded pistol and narcotics in plain view. McMullen was arrested and later charged with being a felon in possession of a firearm. Now, McMullen, through his attorney, moved to suppress the gun evidence, as they do, right? That's what the defense attorneys do, right? That's the defense F word. That's not fair. But they moved to suppress the gun evidence, arguing that the seizure and the searches violated his Fourth Amendment rights. The district court denied the motion, finding that the police had reasonable suspicion of criminal activity to temporarily detain and question McMullen based on factors such as the high crime neighborhood, proximity to a gang member's car, and McMullen's reaching motion towards the car's floorboard. The court also found that the police lawfully Terry frisked McMullen and the vehicle. McMullen pled guilty and then appealed this decision from the trial court. The United States Court of Appeals for the 6th Circuit found that the police had a valid basis for initiating a Terry stop, considering a totality of the circumstances. The court also found that the police took reasonable protective measures during the stop, including the Terry frisk of McMullen himself and the frisk or the protective sweep of his car, and the court ruled it did not violate McMullen's constitutional rights. And the court also rejected McMullen's argument that the gun in his vehicle was not immediately accessible to him at the time of the search of the vehicle, stating that a weapon is not necessarily inaccessible just because it's temporarily behind a closed door, and accordingly, the court affirmed the district court's decision. Okay, so what do we have as a takeaway for this case? First of all, this case brings up a very important Supreme Court decision, Michigan versus Long from 1983. 15 years after the Supreme Court decided the Terry decision, we had Michigan versus Long, where they extended the Terry frisk of a person to a vehicle that a person is immediately associated with, either in it, about to get in it, or about to get out of it at that point in time. So it gives us the ability to Terry frisk a vehicle. Now, this is a very, very important judicially recognized exception, and I've seen a lot of body-worn camera video where officers pulled someone out of the car and Terry frisked the person, but they didn't Terry frisk the vehicle. I don't know whether it's because they just felt they didn't need to or whether they didn't know, but to the extent that it was based on ignorance and not will, it's important. This is a very important case because Michigan versus Long allows us to extend the Terry frisk to a vehicle. Well, obviously you don't pat a vehicle down. We call it Terry frisk of a person, a pat down search. How do you Terry frisk, or how do you do this protective sweep of the passenger compartment? Well, it is a search of the passenger compartment, and you're looking for weapons. It includes unlocked containers. Now, you're looking for weapons, so the scope of the search is going to be narrowed to the place where weapons could possibly be, right? So you always have the scope. There's always going to be a scope limitation. That particularity language of the warrants clause in the Fourth Amendment is always going to be applicable, whether it's a warrantless search or a search based on a warrant. So, what's the purpose of the search? It's to look for a weapon. And that's what the Terry frisk is all about, right? So when you're frisking the compartment, you get unlocked containers, and it's the passenger compartment only, right? The whole purpose of this is the recognition, just like the Terry frisk of the individual, based on this reasonable suspicion that they're presently armed and dangerous. If you have that suspicion that you can frisk a vehicle, then obviously you can frisk the person and the vehicle both. So this is a very important judicially recognized exception. There are a number of exceptions. Although there is no officer safety exception per se, there are a number of JREs, or judicially recognized exceptions, that have as their primary purpose officer safety, and this is one of them. And I've seen a lot of body-worn camera videos where officers pulled someone out of a car. They did a Terry stop. They've stopped the person. They developed a reasonable suspicion this person's presently armed and dangerous. They pull them to the back of the car and they Terry frisk the person, but they never frisk the car. And I don't know if that's a matter of ignorance or just make the decision not to frisk the car. But to the extent it's ignorance, and there have been some situations to where the failure to Terry frisk a vehicle has actually led to officer deaths. And so I take this case very, very seriously in Michigan versus Long, because I think there are a lot of opportunities to use this judicially recognized exception that are not taken full advantage of. And to the extent it's based on ignorance, well, now you know. The next case we have is United States versus Mendez. This case comes to us from the 7th Circuit. It's dated the 10th of June of 2024. After returning from a trip abroad, Marcos Mendez was stopped for inspection at O'Hare International Airport. Customs agents were alerted to Mendez's arrest record and travel history, and they searched his cell phone. The search of the phone revealed the presence of child pornography, and Mendez was charged with the possession of child pornography. And at trial, he moved to suppress the evidence found on his phone, arguing that the search violated his Fourth Amendment rights. The district court denied Mendez's motion to suppress the evidence, ruling that the search did not violate the Fourth Amendment since customs agents had a reasonable suspicion to look through Mendez's phone. Mendez pled guilty to one count of producing child pornography, reserving the right to appeal the district court's ruling on the suppression motion. In the United States Court of Appeals for the 7th Circuit, Mendez argued that the Supreme Court's decision in Riley versus California and Carpenter versus United States, taken together, required a warrant for the search of his phone at the border. The Court of Appeals disagreed, noting that routine searches at the border do not require a warrant or any level of suspicion. So the district court had said since there was a reasonable suspicion, they could search the phone. The Seventh Circuit said that the manual search of his phone at the border, the phone wasn't removed from the border, it was still at the border, that made it a routine search, and this manual routine search of Mendez's cell phone at the border required no suspicion whatsoever under border authority. So what is our takeaway from this case, United States versus Mendez? It's a very interesting case. You know, we don't often get cases that deal with border authority. This is actually a judicially recognized exception. These warrantless searches at the border are done. They're called border searches. There's actually 3 different types of border searches. There is the actual border, like right at where the line is, right? The line in the sand. There is the functional equivalent of the border, both inbound and outbound. You see that when you're on like an international flight like we had in this case. And clearly O'Hare International is well within the border of the United States, but it's the first stop of an international flight, so it has to clear customs. That's the functional equivalent inbound. And we also have functional equivalent outbound. When you're on a flight that is going to leave the United States and land in a different country, this border authority or this border search ability actually still exists. And then we have something really, really fascinating called extended border authority. The HSI, the Homeland Security Investigations Special Agents, 1811s, used to be called ICE agents, and now they're called HSI agents. I actually taught for 2 years at the ICE Academy at FLETC before I went over to teach on the basic side of the house, and I taught customs law and border authority, and it's a fascinating area of the law, and extended border authority is really kind of nifty because you don't even have to be at the border. There's different requirements for it, the reasonable certainty of no change since the nexus, and the reasonable suspicion that there's criminal activity going on. There's a level of suspicion required. It's a little bit different. But this gets really complicated, and that leads me to the last point here. Only certain people have the statutory authority to conduct border searches. If you have border authority, if you are designated in the United States Code through the statutes, if you are a designated customs officer for the purpose of effectuating border searches, you know it. There's no way that you have this authority without knowing it. So it's only exercised by a few people. Every law enforcement officer doesn't have this, and so we don't talk about it a whole lot, and you don't see a whole lot of cases on it. We've seen cases before. Had they actually removed the digital storage device, the cell phone or a laptop or whatever, had they actually removed it from border to a forensic lab somewhere in order to search it, it would have required reasonable suspicion. And that's under previous circuit court decisions. And that's kind of where the district court was heading with this. But that's a non-routine border search, a forensic search away from the border. That's a non-routine search. And they do require reasonable suspicion for that. But in this case, it was a manual search at the border. So it's a routine search and it doesn't require any level of suspicion. And so we don't get many of these, but when we do, I like to talk about them. And this is a great case, a great example of border searches as a warrantless search, judicially recognized exception. The next case we have is United States versus Hoft. This case comes to us from the 8th Circuit Court of Appeals, and it was decided, the decision was issued on June 7th of 2024. At 9:45 in the morning, police officers responded to a call from a storage facility manager who reported an unauthorized individual on the premises who was asleep in the truck. So this is a gated premises, right, where you go through the little keypad at the gate in order to get in. This person's on the inside, and he's apparently sleeping in the vehicle. When the officers arrived, they found Hoft asleep in the truck and observed a loaded crossbow on the passenger seat. The officers woke Hoft and ordered him out of the truck. After Hoft refused to exit the vehicle, the officers tased him, dragged him out of the truck, and arrested him. A subsequent search of Hoft and his truck revealed methamphetamine, syringes, a scale, a handgun, and the crossbow. Hoft challenged the district court's decision on the motion to suppress, arguing that the evidence found by the police should have been suppressed as a result of an unconstitutional seizure. The United States Court of Appeals for the Eighth Circuit affirmed the district court's rulings. When the officers arrived, they knew about the manager's report that a trespasser was passed out behind the wheel of a small white truck, and they saw a truck that matched the description and appeared to be running. Based on these articulable facts, the officers had a reasonable suspicion that Hoft was trespassing and had physical control of a vehicle while intoxicated. Furthermore, ordering Hoft out of the vehicle after his explanation was not unreasonable given the fact a loaded crossbow was within his reach. So what's our takeaway on this case? The only issue on appeal, and this is important to point out, the only issue on appeal was the lawfulness of the seizure. There's no discussion in the case regarding which judicially recognized exception was actually used to search the truck without a warrant. And that brings us to an important point here, that courts only decide issues that are raised. If the defense attorney doesn't raise an issue, and apparently it wasn't an issue, the sides agreed that the search was okay, we don't know whether it was done as some type of frisk of the vehicle. We don't know if it was done as a search incident to arrest. We don't know if it was done as an inventory. We don't know if it was done as under the community caretaking doctrine. We don't know which judicially recognized exception was used in order to conduct a warrantless search of the vehicle in order to do these plain view seizures, right, of the items that were found in the truck. But apparently, the search of the truck wasn't the issue. The only issue raised on appeal was the seizure, and the court ruled in this case that they had all of the reasonable suspicion. They articulated the facts to have the reasonable suspicion that they needed in order to conduct a Terry stop of this individual, which ultimately led to the arrest as a result of what was found inside the vehicle. The next case we have is Johnson versus Smith. This case was decided on June 10th, 2024, and it comes to us from the 10th Circuit. Scott Johnson challenged the constitutionality of a Kansas statute that allowed for the warrantless inspections of their homestead, where Mr. Johnson operated a business that trained and housed bird dogs. They also claimed that their constitutional right to travel was infringed by a statutory requirement that they make the premises available for inspection within 30 minutes of the arrival of an inspector. The district court dismissed their complaint for failure to state a claim. The United States Court of Appeals for the 10th Circuit affirmed the dismissal of the right to travel claim made by Mr. Johnson, but remanded for further proceedings to determine whether Mr. Johnson's business is closely regulated, and if so, whether warrantless inspections are reasonable under the Fourth Amendment. The court found that the government had not shown that the warrantless searches were necessary. The court also held that the regulations do not impose burdens beyond those commonly borne by owners of businesses who travel away from the locations of their business and therefore did not violate the plaintiff's right to travel. So this is an important case under the closely regulated business exception, and this deals with administrative searches. So what is our takeaway from this particular case? Well, this case points out the whole concept of administrative searches are at play here. Administrative searches are not criminal searches. They are searches, however, under the Fourth Amendment. So over time we've developed, the Fourth Amendment evolves like everything else. And we've got these businesses. Some businesses are very, very closely regulated. The drug business, explosives, junkyards. There are certain businesses that are so heavily regulated and closely regulated for the government, for the safety reasons to the population, typically. They're so closely regulated that it allows for warrantless inspections under the administrative search exception for these closely regulated businesses. But businesses that aren't closely regulated, we have to have a warrant. Now, it's not the same as a criminal warrant because there's no probable cause. It's not a criminal search, so it's not based on probable cause. But there has to be a showing of why it is the government needs to perform this administrative inspection. A lot of times we do it under licensing provisions, right? If they fail to allow the administrative inspection, they just revoke the license and shut them down. But in order to perform a search without consent of a business, if it's not closely regulated, we get something that's called an administrative warrant. And it's a Fourth Amendment warrant. It's just not based on probable cause because it's not criminal activity. So the whole question here was whether or not this bird dog training business was closely regulated to the point that would allow for warrantless searches instead of it having to have an administrative warrant. And the burden's on the government, and there was no discussion of this at all. The lower court just said, nope, it's okay under the administrative exception without making a determination if this business is a closely regulated business such that these warrantless administrative searches would be reasonable. And they have to make that determination. It might turn out that this statute, this Kansas statute, is deemed to be totally unconstitutional as it's written, and to the extent it allows for warrantless searches, because the Fourth Amendment's going to trump any state statute, obviously. But that's to be determined. The case got remanded, and we'll have to keep our eye on this to see what happens with this down the road and with this particular statute. Great example of the question about administrative inspections and the difference between warrantless searches for closely regulated business versus the ones that have to have a warrant. The next case we have is Matthews versus State. This is the first of our state law cases this week. This comes to us from the Delaware Supreme Court, and the date of the decision is June 10th of 2024. Antoine Terry was found dead from multiple gunshot wounds. The police arrested Shahid Matthews for the murder. Matthews stood trial for the murder and possession of a firearm during the commission of a felony. And during the trial, the state relied heavily on evidence that was found on Matthews' cell phone. Matthews was convicted and sentenced to life plus 3 years in prison. Matthews appealed his conviction, arguing that his trial counsel was ineffective for failing to move to suppress evidence obtained from his cell phone. Now, usually, this is kind of odd, right? Usually we have the motion's been filed, and then the motion gets denied, and then they appeal the denial of the motion to suppress. In this case, the motion was never filed, and the argument is that it should have been, and had it been, it would have made a substantial difference on the case. It's the ineffective assistance of counsel constitutional issue. The Superior Court in Delaware denied Matthews' motion, and they concluded Matthews had provided valid consent for the search of his cell phone, and that the cell phone evidence had no bearing on the outcome of the case. It's important to point out a fact in this case is that when they asked for his consent to search the cell phone, they told him that they had a warrant, and they did not have a warrant. They lied about having a warrant. So by just telling you that, a very important fact, I think you're probably already going to get a feel for the direction this case is going to be headed. But Matthews appealed the decision of the Superior Court denying his motion to the Delaware Supreme Court. The Delaware Supreme Court reversed the lower court's decision. The court found that Matthews did not provide valid consent for the search of his cell phone, and that the warrant obtained by the police to search Matthews' cell phone after he gave consent was an unconstitutional general warrant. In other words, it was too broad. It didn't have the particularity that's required by the warrants clause of the Fourth Amendment. And the court found that the cell phone evidence was material and very significant to the state's case, and therefore the Delaware Supreme Court concluded that Matthews' trial counsel's failure to move to suppress the evidence obtained from his cell phone constituted deficient performance and prejudiced Matthews. The court vacated Matthews' convictions and remanded the case to the Superior Court for a new trial. So what's our takeaway from this case? What do we have? First of all, most importantly, lying about the existence of a warrant when you're asking for consent to search will negate the voluntariness of consent every time. I mean, this is a common thing. We try and beat this point home at FLETC when we're talking about obtaining consent to search. If you claim false authority, take a piece of paper that's nothing and fold it up and say, we can do this the easy way or we can do this the hard way, right? I've got a warrant, but we would like your cooperation. If you don't have a warrant and you lie about having a warrant, that totally negates the voluntariness of consent. And you should know, consent searches, and one of the requirements is that they be voluntary. And without this voluntariness, the consent is invalid. Another important point on this case, and we don't see this too terribly often, so it's kind of a sub-issue here, and I don't want to really kind of poo-poo it, but it's really important. It's a fundamental thing that sometimes we tend to forget. The Fourth Amendment when Madison put the Fourth Amendment in the Bill of Rights, it already existed under different state and commonwealth charters and constitutions. The notion, it was very, very important that the notion of general warrants we found was abhorrent, and we did not want general warrants. They have to be particular, and that's why we have, I referred to the PC triangle, and if you went through FLETC, you probably saw that PC triangle, and if you do Leo law training, for a fact, you're going to see the PC triangle on the Leo Law portal. The whole notion of the PC triangle when you're completing the application for a search warrant, right? You have to, in the affidavit, you have to establish the facts. You have to provide all the facts to establish probable cause that particular evidence of a particular crime will be found in a particular location, and that's the PC triangle. Without that particularity, it's a general warrant, which is unconstitutional because they're forbidden by the Fourth Amendment. And in this case, the warrant said that they could search the phone for anything. There was it wasn't particular to any type of evidence based on the charges for which the person had been convicted or whatever. There was nothing that limited it. There was nothing particular about it. They were particular about the phone to be searched, right? But they weren't particular about the evidence supporting the crime or what it was that they were looking for. And so it lacked the particularity. So the evidence found as a result of the warrant was no good, and the evidence found as a result of the consent search was no good either. So the evidence gets thrown out, and we have a convicted murderer whose murder has been overturned because of Fourth Amendment violations by the law enforcement officers that were engaged in the investigation of this murder. So it's a very important takeaway. Police officers are very reluctant to use cases to where the cops are found at fault. They want to see all the cases of the good stuff, but they don't want to see cases of the bad stuff. And I get it. And there's a lot of police antagonists out there that are already, trying to put cops down, and I get it. I mean, I really get it. But it's important that we learn from other people's mistakes. The Fourth Amendment is hard, and it's very difficult. And you learn a lot more from the mistakes officers make than you do from when the courts say there was no mistake. Why was this not okay? Compare something that's not okay with something that's okay and find out what the difference is. And in this case, it was clear that lying about the existence of a warrant was just not okay. So this is a really good case. It's a great refresher, a great case to kind of review, to get brushed up on these notions of general warrant and obtaining consent through false statements of authority. The next case we have is Ellis versus Commonwealth. This is a case that comes to us from Kentucky. It was decided by the Kentucky Supreme Court on June 13th of 2024. In this case, John Ellis was convicted of first-degree rape, second-degree burglary, and kidnapping and sentenced to 50 years in prison. Ellis appealed his conviction, arguing that the trial court erred in not suppressing his incriminating statements, which he claimed were made during a custodial interrogation without proper Miranda warnings, and that his girlfriend, to whom he made the statements, was acting as an agent of the state. The trial court had allowed the statements Ellis made to his girlfriend when they were alone, but suppressed those statements made when a police officer was with them in the room. The court held that Ellis's girlfriend was not an agent of the Commonwealth when she was brought into the interview room and allowed to converse with Ellis because she and the officers did not explicitly enlist her assistance. The Supreme Court of Kentucky reversed the lower court's decision, agreeing with Ellis that he was in custody and was not provided Miranda rights advisement as required until an hour and a half after the interrogation started. Furthermore, once advised, his statement that "I think I need a lawyer" was an affirmative invocation of counsel, and the continued questioning constituted an unlawful post-invocation reapproach. The court reversed Ellis's convictions and remanded the case to the circuit court for further proceedings. So what's our takeaway from this case? It's very important to remember the rules for an officer-initiated reapproach after one or both of the Miranda rights have been invoked. And this can get really, really tricky And it even gets more difficult when you throw the Sixth Amendment right to counsel in there. The attachment takes place of the right, knowing when the Sixth Amendment right attaches and then knowing when it's available, when they can invoke it, these critical stages. That's a whole nother, right? It's this concept of reapproaches. It's really, really important. There's two different rights in the Miranda warning, right? They have a right to remain silent and they have a right to have a lawyer present during questioning. They can invoke one without the other. If they invoke just the right to remain silent, then officers can initiate a reapproach after a 2-hour cooling off period. If they invoke just the right to have a lawyer present, regardless of whether they invoke the right to remain silent or not, if they say, I want a lawyer, or in this case, I think I need a lawyer, then the questioning stops and there can be no reapproach until the lawyer is present. There's no such thing as a cooling off period, right? And so in this case, we had two issues at play. First of all, they didn't think they said, oh, he wasn't in custody for Miranda purposes when the girlfriend was in there. He wasn't in custody till later, blah, blah, blah. The court disagreed. They're like, no, he was in custody. The moment you put him in there, he was in custody and he should have been Mirandized, and he wasn't. That means, under the rules, right, about excluding these statements, unmirandized statements, when the court looks at this, when you have an unmirandized statement, when they fail to Mirandize someone when they should, and then they do Mirandize the person, as long as it wasn't an intentional thing, they're not trying to get jiggy with it and do an end around the Fifth Amendment. If you Mirandize the person after realizing the mistake, thinking that they were Mirandized and they weren't or whatever, you Mirandize the person, everything they said before they were Mirandized is inadmissible, but everything they say after they're Mirandized is admissible. So in this case, we had both of those at play. They failed to Mirandize him. They failed to recognize when he was actually in custody. They were in error when they thought custody took place. And so they failed to Mirandize him. And for an hour and a half, he gave statements. He made statements to both the girlfriend and the police officers. Then they Mirandized him. Well, everything that he said prior to being Mirandized was inadmissible, right? It would be suppressed. The statements would be suppressed. After he was Mirandized, he said, I think I need a lawyer. So he invoked. And they argued that was an ambiguous invocation, and the Kentucky Supreme Court disagreed. This is a very important refresher on a couple of these notions with respect to Miranda and Mirandizing. And, we don't get a lot. Most of our cases are search and seizure cases. But when we get a really important Fifth Amendment case, a Miranda self-incrimination constitutional issue like this, it's important to go through it. And so that's what we're doing here for you on this takeaway. The next case we have is Tatum versus State, and this decision comes to us from the Supreme Court of Georgia. Tatum versus State, dated June 11th, 2024. Mark Tatum was convicted of a peeping Tom violation and invasion of privacy for secretly recording a female neighbor through her window. Tatum filed a motion to suppress the evidence obtained from his cell phone, which the trial court denied. The court found Tatum guilty of the peeping Tom violation and the invasion of privacy, and Tatum timely appealed the denial of the motion to suppress. The Court of Appeals in Georgia affirmed the conviction. The court assumed that the arresting officer's warrantless viewing of the video on Tatum's cell phone constituted an illegal search, but concluded that evidence from Tatum's cell phone was admissible under the independent source doctrine. So now we're talking about an exception to the exclusionary rule called the independent source doctrine. The court reasoned that the affidavit supporting the warrant application contained evidence sufficient to support a finding of probable cause, even after excluding information obtained from the officer's warrantless search. The Supreme Court of Georgia granted Tatum's petition for a writ of certiorari and held that when applying the independent source doctrine, courts must consider whether the state's decision to seek a search warrant was prompted by a prior unlawful search. The court found that the record on appeal did not reflect that the trial court considered whether the warrant application was prompted in this way, and accordingly, the court vacated the decision of the Court of Appeals and remanded the case with direction to vacate the trial court's judgment and also remanded for further proceedings. So it's not just enough to say we would have found it anyway. They have to show that the seeking of the warrant wasn't initiated as a result of the evidence they found. In other words, would they have sought the warrant anyway without this knowledge? If they seek a warrant based on knowledge that's illegally obtained or as a result of a Fourth Amendment violation, then then the fact that they were pointed in that direction, that becomes like almost like fruit of the poisonous tree at the warrant level. Kind of an interesting notion there, right? But that's how the independent source doctrine works, and it's an important, we have several important exceptions to the exclusionary rule. We've got the independent source doctrine. We've got the attenuation doctrine that came to us from Utah versus Streff. And we also have the Leon good faith exception, right? Where they have a warrant, even though it was determined that there's no probable cause. The probable cause determination made by the judge was incorrect, but the officer acted in good faith and had clean hands, didn't lie or anything to get the judge to rule that finding of probable cause. Those are your three primary exceptions to the exclusionary rule. But it's important to point out that when you are talking about an exception to the exclusionary rule, you are admitting that there's a Fourth Amendment violation. So the exclusionary rule might help you get the evidence in. The exceptions to the exclusionary rule might overcome that, but you've still got an officer with a Fourth Amendment violation, so that could lead to other things as well. But anyway, we don't get too many cases regarding the independent source doctrine, especially in the context of applying for a warrant. So this is a really good case. It's a state case, obviously limited applicability, but the Fourth Amendment notions are valid and it's instructional. Though for those of you in the state of Georgia, it's the rule of law, but for the rest of us, it's instructional, and it's a good case to kind of remind us of these issues and these doctrines that we deal with in this type of situation. So what's our takeaway from this case, right? Again, the independent source doctrine is an exclusionary rule exception. So we've got a violation of the Fourth Amendment that was based on officer misconduct, because it has to be, right? Not all Fourth Amendment violations lead to the exclusionary rule. It has to be, the basis of it has to be officer misconduct. What we're saying here is that an officer screwed up. There's been a Fourth Amendment violation such that the exclusionary rule would be applicable. However, based on one of these exceptions, it's not going to be. But in this particular case, they would not have sought the warrant, at least arguably. The trial court didn't determine this, but at least arguably, they would not have sought the warrant unless they had this Fourth Amendment violation, the unlawful seizure of this evidence vis-a-vis the Fourth Amendment. And so we cannot use evidence that's unlawfully obtained or fruit of the poisonous tree in order to get the warrant. That taints the warrant. The taint continues on to the warrant. Now, if they can show that they had other evidence already and that they would have sought the warrant and got the warrant even without that information, then if that's the way the court rules, then the independent source doctrine will be applied and the evidence won't be excluded. But if it's demonstrated that they would have never looked for this information, but for the fact that they had this illegally discovered information, that this was a direct result of this without any intermediate or independent source, then the court's going to say, hey, look, the independent source doctrine doesn't apply, and that's why it was remanded in this case. And again, it doesn't happen this way very often. So it's a very interesting case in this regard, and one that's a good refresher for us. Okay, this is a great time before I get to the one use of force case that we have this week, captured audience. I've got your attention. I just want to spend 1 minute talking about Leo Law. Our name is our website address, leo.law. We're very proud. We've been working on this for a little while. We've newly launched. We got a bunch of products coming online. We spent over 2 years working on our search and seizure app, and there's nothing like it on the internet. All of these cases that I'm talking about in this podcast have already been added to the app. The app is broken down into 130 something topics, and it's growing. So I mean, there might be 2 or 3 more by the time this actually goes to air. And they're all broken down and categorized. You click on a topic. Let's say the independent source doctrine, like the case we just had. That's actually a topic inside of the Leo Law Search and Seizure app. You click on that link. It will tell you what the blue key cases, the Leo Law, what we refer to as our blue key cases. Those are the Supreme Court decisions that totally direct and impact that area, that topic. We give you the list of the blue key cases. We give you a summary of what the law is, just a little synopsis that you can read real quickly. If you want more information, you can watch the video. Every page has its own video, an explainer video on that topic. And if you want to know the most recent cases that deal with that topic, they're all right there for you. Scroll down and you'll see the little links, and it'll open up to the case summary for all the cases. And the most recent ones are the ones that are at the top of the list. And so it's an incredible resource for you. The updated weekly, you get notifications every time there's a case added. Love the search and seizure app. Leo Law TV is our TV channel. If you're listening to this podcast on Broadcast Blue, you could be watching it on Leo Law TV. And we do a lot of analysis in the video that we don't do on the audio podcast. And so the Leo Law TV, we're really pleased to be launching that. 5 different channels with all kinds of videos to watch, hundreds of hours of videos on there. The learning portal, the Leo Law Learning Portal, is a self-contained learning management system. We have a lot of information, a lot of courses on there for you, and that's going to be launched at the end of the summer. We're putting together all the stuff. We're trying to make things real easy for you on demand. You don't have to go sit for 8 hours in a course somewhere on the legal aspects of traffic stops. You can take the 8-hour course on the portal in your own time, stop and go back to it when you want to down the road. Fully developed, and the instructional design that we do on this is top notch. This is really important to point out too. Every single legal editor for Leo Law is a retired or a former senior legal instructor from FLETC. They are all FLETC certified senior legal instructors, which is very important. So you can trust the information that we research, we peer review, and you can count on the validity of this information. And then lastly, we have the Search and Seizure YouTube channel, which we fired up to put out some short videos on certain cases and certain topics. And you can follow us at US Leo Law when you get to YouTube. So we have all these avenues for you, and you can check them out. You can get links to all of them at the Leo Law website, leo.law. This brings us to our use of force cases. Sometimes we only have 1 or 2. Sometimes we have a handful. This week we only have 1. And so let's get to it. The use of force case that we're going to discuss this week is Colon versus the City of San Jose. This decision was issued by the Ninth Circuit on June 7th, 2024. Police officers responded to multiple 911 calls reporting a man with a gun. They located Francis Colon, who appeared to have a gun in his waistband. They followed him for about a minute as he walked down the street. Officer Edward Carboni then shot and killed Colon. Colon's mother, Rosalina Colon, sued Officer Carboni under Title 42 of the United States Code, Section 1983, for violating her son's Fourth Amendment right to be free from excessive force. And so, as you know, these are civil suits in federal court for the deprivation of rights under the color of law. So we have a use of force. This is a use of force case. It's based on deadly force. The son killed by the force applied by the police officer. So this is going to involve qualified immunity, right? And the district court granted summary judgment in favor of Officer Carboni, ruling that he was entitled to qualified immunity because the plaintiff had failed to identify any specific case law that clearly established that Officer Carboni's conduct violated the Fourth Amendment. The Ninth Circuit reversed. Using the testimony of other officers who contradicted Carboni's version of the event, the court resolved 3 disputed facts in the plaintiff's favor for the purposes of the appeal of summary judgment. First, Colon was not drawing his gun or making a threatening gesture when Officer Carboni shot him. Second, there were no bystanders in Colon's vicinity that were endangered when he was shot. And lastly, officers did not instruct Colon to get on the ground or stop before he was shot. The appellate court found that when construing the facts in the light most favorable to the plaintiff, as they do in a summary judgment, a reasonable jury could decide that Officer Carboni violated Colon's Fourth Amendment right to be free from excessive force. The court also concluded that the relevant law was clearly established at the time, so Officer Carboni was not entitled to qualified immunity at this stage. The court held that the totality of the circumstances did not justify deadly force. So this is a case of qualified immunity getting reversed, getting taken away. There's a whole lot of stuff going on procedurally. I've watched a couple podcasts and I've watched a couple of free webinars from other folks trying to explain the nuances of qualified immunity. I mean, it's a big, big deal. The whole thing with use of force is obviously a big, big deal. So it's important that you understand the different stages and how this works. But basically, when you have a motion for summary judgment, the plaintiff, in this case, is the family of the person who was shot and killed. The defendant is the police officer in this civil action. All the police officer has to do in a claim for excessive use of force is, say, qualified immunity. And the burden shifts to the plaintiff in the case to show that, one, that the rights were violated, and two, that it was clearly established. And those questions don't have to be answered in any particular order. In this case, in the way these things work on summary judgment, they always view the facts in light most favorable to the plaintiff. And because that's the non-moving party, the person asking for the summary judgment of qualified immunity is the defendant officer. So they say, well, if we have disputed facts, we're going to take the facts that are most favorable to the plaintiff, because if we have a qualified immunity, if that exists under those facts, then there's no point in taking this to a jury, right? But if we have facts that need to be determined, it'll go to the jury. And that's the court said in this case, in the facts most favorable to the plaintiff, that a reasonable jury could decide that the Fourth Amendment rights were violated. So the qualified immunity, a decision granting qualified immunity was reversed, which means the case will go to trial. So I already talked a little bit about qualified immunity on summary judgment. It's a really important notion, and it's not typical. Qualified immunity isn't a typical type of summary judgment. Let me give you an example. Anybody can move for summary judgment in a civil suit, and basically what you're saying with summary judgment is, and you do this after discovery, depositions, interrogatories, you get all the facts out there, and what the one of the parties is saying is that there is no issue of fact. We agree on all the facts. So the only question is a question of law. If there is no question of fact, there is no need for a jury, because that's what juries decide. Juries are the triers of fact. The judge is the trier of law. The judge and the juries have their two separate roles. If the facts are disputed, then the judge can't determine as a matter of law whether or not summary judgment is appropriate. It has to go to the jury to resolve the facts. Now, the court in Scott versus Harris, you might remember the Scott versus Harris decision where they ran the kid off the road, and it turned out he became a quadriplegic as a result of it, right? But what was really fascinating about that case that might have slipped you, because you're focused on the facts and stuff, right? They used the dash cam video in order to determine that the facts as presented by the plaintiff were not plausible. So they were saying, look, the facts asserted by the plaintiff, the dash cam video totally proves that this isn't right. And so they ruled on summary judgment based on the video. So that was an interesting twist. And now we do that with body camera video. There's a lot of cases to where excessive force cases that are filed where they're dismissed or they are granted motions of summary judgment for qualified immunity just based on the body camera video, because the body camera video shows that this didn't happen the way the plaintiff said it did. So this case is really interesting because we have a situation where it's not camera video, body camera or dash cam video, that is establishing whether or not the plaintiff's version is true. It's other officers who said that the defendant officer's version of the events is not the way it happened. So you've got numerous officers saying that's not what happened. Then the court took that, they put a lot of weight on that, right? When you've got one officer saying this happened and the other officers are like, no, it didn't. And there's body camera video. I mean, obviously it's going to put you in a situation where you're not going to get qualified immunity as an officer, but it doesn't happen very often. So this is an interesting case for those purposes. Okay, thank you so much for joining me this week. I want to start something new. I'm going to do an agency of the week every Broadcast Blue episode. At the very end, I'm going to give a shout out to a Broadcast Blue agency of the week. And we're going to start with the Castle Rock Police Department. I can't think of a better department to start with out there in Castle Rock, Colorado. It's really beautiful out there on the eastern slope. I'm kind of a western slope kind of guy myself, but out there, the eastern slope, beautiful as well, Castle Rock, Colorado. And Chief Jack Cawley, who has implemented his one-by-one policing program, which is just outstanding. The culture that's been developed at that department through his leadership is nothing short of amazing. And Jack's very involved with the International Association of the Chiefs of Police. He's also a part of the CURVE initiative. If you want to follow the CURVE on LinkedIn and see the really interesting things that they have going on. Jack's one of a number of police chiefs, police leaders who are involved in this project, the CURVE initiative with Simon Sinek. So I want to Give a shout out to Chief Colley and all the fine folks out there at the Castle Rock Police Department. And hopefully I'll be out there soon providing some constitutional policing training for you. Thank you so much for what you do out there, and a shining example. I'd encourage folks to look up the department. Google them, look up the Castle Rock Police Department, and see what they've got going on with this one-by-one policing initiative that they have out there.
You've been listening to Broadcast Blue. Broadcast Blue is a production of Leo Law, a division of V-Stars U.S. Incorporated. All discussions on the legal topics in this production are purely for academic purposes. No part of this production is offered as, nor should be construed as legal advice. If you have any questions regarding any part of this presentation, you should contact your agency legal representative.